Greetings everyone. Once again, welcome to my YouTube channel. This week it is Child Protection Week. And for that reason, I want to briefly look at what the law in South Africa says about children's rights. In particular, I want to look at what the Constitution says. Section 28 of the Constitution of South Africa talks about the rights of children. This is despite the fact that there are many other pieces of legislations, or should I say there are many other laws in South Africa that talks to the rights of children, that talks to the protection of children. However, I'm sure we are aware by now that the Constitution of South Africa is the supreme law of the country, is the highest law of the country. So every other law, every other statute that is enacted must be aligned to what the Constitution says. So much so, if that law is contrary to the Constitution, is opposing what the Constitution says, it's not in line with what the Constitution says, that piece of legislation, that law will be declared invalid, because all laws must be aligned to the Constitution. That is why from 1994, 1996, after the Constitution was now finalized, because you must remember the Constitution of South Africa is a 1996 constitution, but prior to that, there was an interim constitution. So since the constitution now has been finalized, every law in South Africa was aligned to this constitution. Now, in terms of the constitution, the very section 28(3), a child is any person under the age of 18. Now, Section 28, subsection 1, provides for the rights of children. Every child has a right to a name and to a nationality. So in other words, at the time of birth, a child must be given a name because he has a right to a name. A child must be placed in a nationality. That is why in most jurisdictions of the world, even if a child is a foreigner, or let me say the parents are foreigners, and they gave birth to a child in that state, in that foreign country, in most instances, the child would adopt the nationality of a state or of a country where he is born. A child also has a right to a family, to family care, to parental care, or to appropriate alternative care when removed from the family environment. So number one is family care, it's parental care, or is alternative appropriate. You know, there are instances where the courts will decide that the child is better placed somewhere instead of being with his or family, or instead of being with his or her parents. There may be an alternative appropriate care or place where this child can be placed. It can be because maybe parents are not there, maybe they are deceased, or it can be because for one reason or another, the parents are not better placed at that time to be the ones offering that care to a child. For example, maybe the mother is neglecting the child, ill-treating the child, and so on and so forth. In other instances, maybe it's because they are not in a position to provide for the child. This child, instead of him being afforded or offered this family or parental care, will be taken to an alternative appropriate place for the child to be cared. And the key word there is appropriate, because it must be appropriate. The child cannot be removed from parental or from family care and to be placed in a place which is worse than where he or she was. So it must also be appropriate. We have seen children being taken to shelters because they were abandoned. That will be another a scenario of an alternative appropriate case. But it is important that the child is removed to a place which is appropriate. The child is also, he has the right to basic nutrition, shelter, health care services, or social services. That is why you'll see in South Africa, the Constitution obliges even the government to offer those services. That is why you see today, even in schools in South Africa, they have this nutrition scheme where children go to school and they are offered a meal there. For some of those children, the meals that they get at school is the only meal for the day. That is why even in some instances, even when the school closed, these children will be starving. The children must also be afforded appropriate shelter, health care, social services. That is why in South Africa, you see that for needy children, for orphans, they have grants. The government gives them grants. There are grants for children. And in terms of the Constitution, again, they must be protected from maltreatment, neglect, abuse, degradation. Those are the rights of children. You must remember that children fall within the category of vulnerable persons of our society because the children cannot fight for themselves. They cannot provide for themselves. They cannot protect themselves. So it's so easy for them to be maltreated, to be neglected, to be abused, or even to be degraded. So these are some of their rights, and they need to be offered protection in terms of these rights. The children will also be protected. One of their rights is to be protected from exploitative labor practices. We have seen it in some instances where children were made to work at a very early stage instead of being at school. It is unlawful for a child of a certain age not to be going to school because that's where children should be, at school at a certain age. Therefore, these rights are also enshrined and protected in the Constitution. Children are also not to be required or permitted to perform work or services that are not age appropriate. So in other words, even if a child is to work, even if it's at home, the kind of work that the child does, it must be age appropriate. You cannot expect a 5-year-old or 6-year-old to be cooking. But we have seen it in the media where there are instances where An 8-year-old staying alone. I've seen it in newspapers, in the internet, where you'll see an 8-year-old staying alone or being a head of a family because the parents are not there. They are not to be placed at risk to their well-being, to their education, to their physical or mental health, or even to their spiritual, moral, or social development. This is what the Constitution said. This is what the Constitution says, rather. Children are not to be placed at risk. Anything that puts their physical health, mental health at stake, they are not to be placed at that risk. The Constitution also provides that children should not be detained. Children should not be detained unless it is a matter of last resort. And when children are detained, they must be afforded legal representation. Because why? They cannot speak for themselves. And the right to legal representation is a constitutional imperative. Now, having said that, when you look at Section 28, subsection 2 of the Constitution, it says, in all cases, in all decisions that are to be taken regarding children, what should be considered when those decisions are taken? What is of paramount importance in every case that involves children is the best interest of the child. Say, for example, it's regarding custody or parental care. As a way of an example, if the parents divorce, it's not automatic that the child will go with the mother. Though in most instances, if it's a minor child, the minor children will go with the mother. But now, the main question or the main consideration is it to the best interest of the child that this child should be placed with the mother? If it is for the best interest of the child, then yes, the child will share custody, will be placed with the mother. So each case will depend on whether it is to the best interest of the child. Every decision, whether it's custody, whether it's maintenance, whether it's schooling, when decisions are taken of paramount importance, the most important question that we ask, is it to the best interest of the child that we should take this decision? And if it is, then that particular interest, that particular decision, rather, that serves the best interest of the child is the one that should be taken. I thank you.